Mes chers collègues, it is a very great honour as President of the CCB to speak at the conclusion of this excellent seminar discussing lawyers at the heart of Europe protecting against injustice. I thought it would be very challenging to sum up in some 15 minutes everything that we have been discussing today, but of course the messages are complementary and we are all very much conscious of what our respective roles are in this important challenge. The CCB represents the bars and law societies within Europe. We represent them to the European institutions and to other international bodies. We represent them in order to protect the independence of the legal profession and to ensure that with a strong, vibrant, independent legal profession, citizens have access to justice, and through that access, the rule of law is maintained. It was accordingly a great privilege to be present today listening to so many excellent speakers with different perspectives on the challenges facing lawyers to ensure that we attain the goal, which is the rule of law. Lawyers are at the heart of protecting rights. That has to be accepted by the institutions, and we are all working very hard to secure a binding convention on the role of lawyer to protect vulnerable lawyers and to protect the institutions of justice. And Laurent Petit obviously has commented on this earlier on. The first roundtable that I want to comment on was the roundtable towards which new European procedural guarantees. And that is a very familiar topic to the CCB because we have been working on this for many years. On the criminal law side, we saw how the Green Paper never got the political support it needed to secure even the modest measures that were envisaged then. However, when the Stockholm programme was announced and the measures were introduced one by one, they met with significant success. It's now time to look for a new roadmap, new procedural safeguards, and we will be active in doing that. In a specific context, the European Public Prosecutor has now been established and is starting her work. We will be open to the possibilities for that office, but we will also be cautious that the safeguards that are needed are provided, and in particular the resources that are needed to ensure that people get a fair trial and proper access to justice is in place. I think that some of the key messages that came out of the panel might be summarised as follows. Jérôme Gauvaudin, well, I agree with him that we must be very vigilant about the threats from within the European Union, and it's also time, as he pointed out, to give more resources to the European Court of Human Rights so that it can do its own important work more efficiently. The bâtonnier of the Paris Bar, Julie Coutumier, made the very important point that many lawyers miss, that European Union law is a source of law. It's not simply a branch of law, and it is part of law for us all and every day. Bruno Blanquet gave an excellent summary of the threats to the European Union and the challenges ahead, and I think we all learned from what he had to say. Bruno Huck similarly put the European Convention on Human Rights and the work of the European Court in a context for us all to follow. Laurent Petit did an excellent job of presenting Panagiotis Periakis' paper on procedural safeguards and the need to be patient. And I think that it was pity that Panagiotis is in the same boat as myself, or at least not in the same plane because we couldn't travel. We'd like to have been here at the conference, but the words as spoken by Laurent had real force and indicate the steps that the CCB will continue to take in this area. We then had the contribution of Laurence Huet, who gave an excellent reprise of how we got to where we are today, linked with some up-to-date information on references to the Court of Justice on the right to information. I'd probably have to agree to differ on the reasons for enforcing and not enforcing a European arrest warrant, but that's just what lawyers do. The next roundtable was one that is very close to the heart of the CCB. That was the roundtable on how to improve the protection of migrants' rights. And I'm very proud to say that the CCB have been heavily involved in this with the European Lawyers in Lesbos project, supported by our German colleagues in particular. Naomi Alarcon gave us all a very clear and practical explanation of what is involved on the ground. And she then did a further tour de force by presenting Philip Worthington's paper on the same topic. At the end of that, of course, we were all very clear about the difficulties and the importance of the intervention of lawyers. And as Laurence Roch made point perfectly plain, it's the point when there is legal intervention is the most critical. Before the next panel, we heard from Commissioner Renders. Commissioner Renders has impressed us all with his understanding of the challenges for lawyers, and in particular, his understanding that effective access to justice means lawyers who've had effective training and effective resourcing. And he has given a commitment that we will follow up with him on to improve training throughout the European Union of our professional colleagues. We then moved on to the roundtable on corporate social responsibility and what role for lawyers. And again, this is an important topic for the CCBE. We've had a committee dealing with this issue for over 20 years. We've issued and revised our guidelines. We appreciate the importance of this in law firms and in society generally, and we will continue to work on it. There were some very interesting contributions in this topic. Leila Kajacek highlighted the special issues of gender, age and displacement, topics that are often not given the priority that they should in legal discussions. Caroline Zorn set out other challenges that we all know from individual member states. Laurent Martinet gave a very helpful historical overview. Pascal Durand spoke that civil and common lawyers have much in common and more in common than we think on the theme of corporate social responsibility. Again, I would have to agree with Tiffany Koninin that there are unfortunately some colleagues and some law firms whose interest in corporate social responsibility is not a genuine interest. It is a material self-interest, and that is inimical to the interest we want to promote, which is an interest in the public interest. We then moved to our final panel, which was on the theme of tools to fight judicial intimidation. And we started with the Vice Batonnier of Paris, Vincent Niore, who gave a very stirring speech extolling the importance of courage for lawyers. And that is reminding us all of the important work we do and the need to be courageous in the face of vested interests who do not want our values to prevail. We then heard from Mathieu Boisavie, and he spoke passionately and knowledgeably on the issue of defamation. I would take issue with him, I suppose, to the limited extent that defamation law is there to protect the good names of people who are unfairly targeted, sometimes by powerful media interests, and that defamation proceedings are not necessarily an abuse of the process of the courts. We will be dealing with much discussion on the anti-SLAPP initiative currently being debated, and it is striking that the politicians either are not aware, or perhaps for media interests are not reported as being aware, that in all of our jurisdictions we already have remedies in place to stop the malicious abuse of the civil process. So we must be cautious about anti-SLAPP. We don't want people being oppressed, particularly legal colleagues, by improper litigation, nor do we want to see citizens lose the one protection they have, which is access to the courts and access to justice. None of us could have been other than moved by the contribution from our Polish judicial colleague, Paweł Jusiskin. We know what is happening to our Polish colleagues. We stand with them and we will continue to support them as they stand bravely for the rule of law in their own country at this most difficult time. Equally, Hania Gutier made observations in relation to the wrongful surveillance of lawyers. Again, we talk about Poland, but we could be talking about any of our member states, and the CCB will take a strong line to protect lawyer-client confidentiality from improper interference, whether by state authorities or others. Finally, we heard from Paul Copin, and he gave the point of view of journalists, and I can assure him that the CCB are very much in favour of the free and independent media, and nothing that we may say from time to time on media issues will ever take away from that. It is a core value of our society. So, in summary, I would just like to thank you all for participating in the conference today. I'd like to thank our French colleagues for organising it. It was a very timely start to the legal work of this year, and it has refreshed us all to be able to concentrate working with such wonderful colleagues on such important topics. Thank you.